So we're still on section 1 for remedies, but we're in the second section of section 1. And we're going to talk a little bit about lawyers using other than court methods to resolve disputes. We're also going to look at a couple of the cases with respect to injunctive relief and the use of injunctions, because when we talk about equitable remedies, more often than not, we are in fact talking about some form of injunctive relief. Not always, but quite common. And so we're going to look at the cases of Weinberger, Clinton, and Norwalk. But first I want to take a quick look at Rule 65, which Rule 65 of the Rules of Civil Procedure does govern how injunctions are issued and, in fact, what an injunction is. You already know that there are 3 different names to an injunction, and they differ in name depending on when they're sought. A temporary restraining order is sought at the outset of the case, or can be sought, and it can be sought even without notice to the other side. The problem with obviously trying to obtain an injunction without notice is the fact that that doesn't provide the due process that the Constitution mandates. So if you are going to try and get an injunction without notice to the other side, which is permissible, you really better have an extraordinary situation such that there really is no time to give the other side notice before you obtain that temporary restraining order. It's very, very difficult, and when you think about getting a TRO without notice, oftentimes from a practical standpoint, what the court may well want you to do, especially if you've been in contact with the other side before seeking the injunction, before filing the complaint, is they may want not the notice that a summons would provide them or a short order of notice, but what would be the notice, even a phone call or a letter. Do they know you're in court today is a question that the judge may well ask you when you seek a TRO, because they want to know whether there's been some attempt to contact them. Because realistically, we don't get the same hearing. We don't have the same presentation of information if there's no adversary there. So don't seek a temporary restraining order as a matter of course. You save it for those extraordinary situations where there really is no opportunity to give notice to the other side. If the court is going to hold a hearing, oftentimes then the hearing would be held relatively early in the case, and that would be then likely to be considered a request for a preliminary injunction. It's at the start of the case, good for the duration of the case, and usually then the other side has the opportunity to present documentation and information, and as we're going to see in the cases, there may be even an opportunity for that hearing that's required on a preliminary injunction to be a full hearing where witnesses will be present and the like. We're going to look at cases in that regard. The last of the 3 names we give to the lives of an injunction is a permanent injunction, which is only issued after the case has been heard, either by way of summary judgment or by way of a trial. If you're going to seek a temporary restraining order, preliminary injunction, or permanent, then as part of your complaint that you file, you would request such orders and you would describe what it is you want those orders to say. The rule says, Rule 65 says, if you look at it carefully, that if you're going to move for injunctive relief, you either have to do so by way of a verified complaint or with affidavits, because your complaint merely are allegations of what you say the facts are, and unless they're sworn to in some capacity, that's all they are, is allegations. So oftentimes, when you move for summary judgment, move for injunctive relief by way of a motion, with that motion would be affidavits that are signed under the pains and penalties of perjury, affirming the facts that you say exist that justify your request for injunctive relief. When you seek injunctive relief, the court always applies a 5-part test. The court has to make a determination that there is what we call no adequate remedy at law. Right? Money damages won't make the plaintiff whole. Second part of the test is the movement has to establish the likelihood of success on the merits. Third part of the test is that the movement must show immediate, irreparable injury. And that is the whole nature of this process. You say, we can't wait for the case to ultimately be heard a year or 2 years from now. The harm is so severe and likely so irreparable that we need some type of relief while the case is ongoing. The fourth part of the test after III is the balance of harms. The court has to weigh the competing harms. Movement says that they're suffering harms, but so is the plaintiff. So is the other side, which is usually likely to be the defendant. The court has to balance the competing harms there if the injunction is not granted versus what are the harms when the injunction is in fact granted. And the fifth part of the test is what, if any, public policy considerations are at work here. And while they're not always present, oftentimes there are public policy issues as well. The court then, based on the papers or the hearing, decides whether to issue the injunction. And if you read Rule 65, it also talks a little bit about a bond being required to be posted as part of the process as well. That bond is supposed to be posted in the event it's later determined that the injunction was improvidently granted. And that bond then is there to reimburse the party against whom the injunction was issued, to give them their costs, their losses as a result of that injunction being improvidently granted. If you sought a temporary restraining order in court, Superior Court or federal court, then that's the other thing. Not all courts are authorized to grant injunctive relief. In Massachusetts, the most common place that people seek injunctive relief is via Superior Court. Massachusetts District Court does not have the power to grant injunctive relief except in a few specified cases. What will happen sometimes if you go in without providing notice to the other side, instead of giving you the summons or you receiving the summons, the court may give you what we call a short order of notice. And a short order of notice simply is a summons that has a set return date. So you might go in seeking a TRO saying, Your Honor, I can't give them notice, and you're in on a Monday. And the court will say, well, I'm not going to grant the TRO, but I'll give you a short order of notice. Serve it on the defendant, tell him to come back on Friday at 2 o'clock, and I'll decide, I'll have a hearing at that point. So at least there are ways in which to provide notice that still will give you a great deal of speed, as opposed to having to wait till the complaint is served 20 days later. Then at some point the defendant files an answer and off we go. Injunctive relief tends to move faster in court, again, because, at least in part, because you're saying you're suffering immediate and irreparable injuries. And the fact is that if you are, or likely to be, then that case should be a priority for the court to try and resolve. So sometimes parties will seek injunctive relief, at least in part, as a means of advancing the case more rapidly on the court's calendar. As long as you've got a legitimate claim for injunctive relief, there's no problem with that. What you should remember, obviously, though, is that your equitable claims, your claims for injunctive relief, declaratory judgment, other equitable type remedies, you do not have a right to a jury trial. You would have a right to a jury trial on your money damage claims. So that has to some extent be coordinated as well. Do you have questions on Rule 65? Because if not, I'm going to go to Weinberger versus Romero-Barcelo. But we're going to look at injunctions again from time to not from time to time, but in some greater depth. But do you have questions on the rule itself? Rule 65, whether we're in federal or state court, is virtually the same. And the other part we haven't talked about, but again, we'll talk about it later in the semester. Since it is an order of the court, the order should be clear. If you're seeking injunctive relief, you draft the order. You tell the court what the order is you want. And the reason it needs to be clear is it carries with it the sanction of contempt. So that the fact is, if an injunction is violated, it potentially means that you could be in civil contempt. It potentially also means that you could be in criminal contempt, depending on what remedy the court chooses, or you choose, to try and seek enforcement by. Questions on injunctions? We're going to see a lot of them before we're done. Let's talk a little bit about Weinberger versus Romero-Barcelo, and then we'll turn to some of the articles on settling. And obviously, when we think about trying to resolve things with mediation, conciliation, and just sort of adjusting our thinking as opposed to the pure litigation model, one of the concerns is, well, how do we even get them? One of the concerns realistically is, how do you even get them to the table? How do you get them to realize that if we did this at the outset of the process, that we would both save tens or hundreds of thousands of dollars in attorney's fees? Because my experience in civil litigation, more often than not by a wide margin, 9 out of 10, that when we get serious about mediation, conciliation, or settlement, is usually as we're getting very, very close to trying the case. And what that means is both sides have spent an enormous amount of time and resources on discovery and all of that it entails. Unfortunately, my experience is, and there are a few exceptions along the way, is that if without the hammer over a party of thinking, we're going to go to trial soon, and I could lose a lot, either way, that it's hard to get people to realize that talking and trying to reasonably assess the merits of their claim, unfortunately, often has to take place with some threat of more significant damage soon, for people to be realistic about the value of the case and whether it's worth it to settle or go forward. And I think some of that is the incentive that lawyers have to charge fees all the way through the process, especially from a defendant standpoint. They generally work on an hourly basis, and there's no sense losing that money until we have to. But let's talk a little bit about Weinberger versus Romero-Barcelo. This is a federal court complaint, and it's based on a violation of a federal statute. They're seeking injunctive relief in the case, and there's a variety of federal statutes here and that are in issue. And that's, again, something I want you to start to see as you read these cases, is that if you look at the first footnote in this case, I mean, this complaint lists probably somewhere north of 10 different statutory violations that they're charged with. And so that's maybe a little high, but quite often in the real world, we file multiple count complaints. We might file in a relatively simple case a complaint that has 6, 7 counts to it, and those counts are alleging different legal theories as to why we should win. And so we do plead in the alternative, and you should plead in the alternative. Sometimes the claim at the outset that you think is important and solid, as you get through discovery and the like, you realize that that may not be the best one you have. One of the others may be significantly stronger than you originally assessed it at. I assume you've read the case, and I'm going to assume you've read all these cases, so we're not going to just simply recite the facts of the case. So I want to know, from the standpoint of Weinberger versus Romero-Barcelo, people of Puerto Rico are seeking the injunction. They say it's a pollutant. Congress, in my opinion, seems to agree. Shouldn't they get the injunction? Shouldn't they?
Well, they waited until the last minute.
What do you mean they waited till the last minute?
Well, they knew about it in the spring.
They knew about what in the spring?
The change in the school.
Changing what?
The school.
Hold that thought. Well, okay. Weinberger is the people of Puerto Rico versus the U.S. government / U.S. Navy. If they were your clients, I mean, how do you tell them that they shouldn't win here? Or that justice is served when they don't win? Go ahead.
Well, I think you would have to bring in, like, the 5-part test, the public policy concerns. If they didn't train, then what would that do, you know, to the safety of the country, I guess?
Right.
So that trumps everything else?
Well, also, they failed to show immediate irreparable injury, where there was actually more wildlife in the area where they were bombing than the areas where they, were open to fishing. The rest of it.
Go ahead.
I remember when we went over this, it was 3 years ago.
You've been here a long time.
Yeah.
Time to get out.
But there was a girl in my class from Puerto Rico who stood up and said that actual case and what they were doing actually caused a lot of health problems for the people there later on. Like, that it turned out like people were getting cancer and stuff. And they traced it back to cancer.
Well, but is that then, so there was harm there and the people of Puerto Rico didn't prove it? Or, with respect to at least part of it, I always worry about when I read these cases, doesn't the court have to say there's no harm? I mean, how do you say, oh my God, we've got a bloody disaster here, but I'm not going to do anything about it? When you grant or deny injunctive relief, that's one person. And I can't really tell you that I'm going to leave a bloody mess behind, but I'm not going to do anything. To some extent, the logic is a little circular. I've got to say, no, it's not that bad. Some of the finest fishing grounds in all of Puerto Rico are found there. Yeah, well, who the hell's going to be fishing if there's bombs dropping from the sky? I mean, it would tend to deter a lot of people fishing. Geneva?
I was just going to say that it wasn't the only remedy that they had. Like, they had other sanctions they could give, fines and things like that, penalties to prevent people from doing that, and then to fix problems of pollution. So, I mean, there is another adequate remedy at law, and they shouldn't be throwing around prior restraints just because somebody wants them to stop.
Okay, so they've got other measures, you guys think? Other measures that in the modern trend in remedies is that will be as complete and effective of relief as injunctive relief. What, get the permit?
I don't understand.
Well,
Huh?
they're requiring a
Like, don't
permit.
throw bombs when people would fish. Like, I don't
Yeah,
understand.
aren't they requiring that they get a permit, and there must be some time limit? I didn't see where there's a time limit.
Well,
They're just not.
there is no time limit, is
They're
it?
not giving them, they're not, ordering an injunction, but that doesn't mean that they're not gonna cause them to cease the behavior if they don't obtain the permit.
Well,
right?
where does it say that, Fred? I mean, I'd like
Well,
to think
it
that there was
says
some.
they upheld the district court decision. The district court ordered them to get a permit through the EPA, right?
Did it?
Yeah.
Where does it say that? Huh?
I remember there being an issue.
Well, there is an issue about the permit, but the suggestion is that there was an order to go get the permit, which would mean they gave some form of injunctive relief.
Yeah.
So what's it
Well,
say?
they're not stopping them. They're ordering them to get a permit, but that's what's unclear to me. And when, if they fail to get this permit, when do they have to stop?
Well, there's no, let's be
It
clear.
says
There
the
is no
district-
order that says they have to stop, period, from
Right.
either the district court or the appeals court, right?
I think what Fred is mixing up here is it says over here, the Court of Appeals for the First Circuit vacated the district court's order and remanded with instructions that the court order the Navy to cease the violation until it obtained a permit. That's not an order to get a permit, that's just saying that they would have to cease until they get the permit. It's not a court order.
Well, let me ask you that. What does the district court do?
The district court said, order the Navy to apply for an NPDES permit, which is
Right.
a type of permit. It refused, however, to enjoin the Navy operations pending consideration of the application for the permit. So
Okay.
it said they needed to
So they
get a
ordered
permit,
them
but
to
they
get a
didn't have
permit,
to
they
stop
just don't do
the
the
action
activity.
while they were trying to obtain the permit.
Okay, so you guys should get a permit, but I'm not gonna do anything beyond that.
Right, but there's some implication that if failure to get that permit.
Where's the implication? Yeah, I mean,
Well,
yeah,
no,
we would think,
it's
logic would
not
say,
logic
says that if they don't get the permit, something bad's gonna happen. But it doesn't say that, though, right?
No, it doesn't say on such and such a date that, you cease and desist if you haven't obtained a permit. That's the irony of the whole decision.
When I was reading it, it was almost like, why should we enjoin it? Because they're just going to do what it takes to get a permit and be able to do it anyway. So I kind of got the sense of that. I had a different sense of it.
But what about that? I mean, where does the permit come from? Because I thought the Navy's argument was, at least in part, the suggestion also is, we're not gonna get a permit. Who has to issue, at least in part, the permit?
The EPA.
Well, doesn't the Commonwealth of Puerto Rico have some say in it as well, or is it just the EPA?
They do, and they would never gonna.
And they wouldn't give it to them.
No, they
Puerto
won't.
Rico wouldn't issue it.
Because they don't want to man them.
Right.
And it's their land. So the district court denies the injunctive relief, right? And the appeals court, Ray says, where'd it go now? I just had it.
Page 20, all the way at the bottom.
The Court of Appeals for the First Circuit vacated the district court's order and remanded with instructions that the court order the Navy to cease the violation until it obtained a permit. And the court felt that they, at least the appeals courts are, that they must grant injunctive relief under the statutory scheme. But as I think Geneva said, earlier on, what the biggest concern is on the balance of harms and the public policy issues is the Navy's playing the national defense card here, saying, you know, you better really be careful what happens here and what you choose to do, because we need to be doing this activity here. And I guess implied in that is that there's no other place in the world that we can do it. Ultimately, we get to the Supreme Court, and we'll talk about that in a minute. What about this issue that you guys said that, did Puerto Rico really put in evidence of actual harm? Right, I mean, that's, some of you said when looking at the case is that, you know, there is some suggestion, and in fact, we did have someone in our class say, you know, there is not just evidence, but actual proof of real harm, although reading this case, it doesn't appear that it was ever offered. Did they just do a lousy job, or is there any job that they could have done that would likely have overcome the 800-pound gorilla, which is the U.S. Navy saying, we need this for national defense?
Right. It's a balancing of harms thing,
And-
argument, right? I mean,
Yeah, right.
even though they may have shown harm, the balancing of harms, the court decided the granting of injunctive relief sought would cause grievous and perhaps irreparable harm not only to the defendant Navy, but to the general welfare of this nation.
So their harm trumps everyone's, even if Puerto Rico had put some evidence of harm in. And I do think, in part, the argument is that they didn't put enough in, but even if they had put in, my guess is, extraordinary harm, could the court still find that the Navy's argument trumps at the end of the day, that, listen, you guys are going to be inconvenienced, doesn't really say it properly, but you guys are going to be, well, I'll say it this way, you guys are going to be sacrificed for the greater good of our national defense. Man up. Yeah, so that's still going to win even if they put the harm in. Go ahead.
I was just going to say, because a lot of, from what I took from the case, is that they were trying to argue whether the court had the discretion to
That's
give
correct.
or not give an
Yep.
injunction, so still the court would have discretion to not give it, and I guess it really would depend on how much evidence they brought in about harm, and then how much evidence the Navy brought in about how it would affect national security, that's still likely going to outweigh the pollution. Because again, with pollution, you could then force them to pay money to fix that problem or to clean up or something like that, rather than making them stop breathing or.
So at the end of the day, the discretion is so great that as long as the court does the analysis properly and weighs the appropriate factors, it virtually can do whatever it wants with respect to that request for injunctive relief. Go ahead.
If I'm on the same case.
We'll let you know.
I think that the plaintiffs were naive in thinking that just by stating the violations per se was enough to embarrass everybody, but it was a huge political football. And I think that, you know, if you were able to put up enough of a plaintiff's case to show, you know, to embarrass them into not being able to ignore when you bring people in with missing limbs or birth defects or whatever, you know, the more of a dog and pony show you can put on, the harder it's going to be for them. But otherwise.
Well, do you think, or do you think,
Oh, I think
Eva
so.
says, no, at the end of the day, put on all your damn harm you want. And we're gonna still trump that at the end and say, lives are at stake.
Yeah, national defense will trump, that's a big
No,
card.
no matter what you have.
I don't know.
Well, why
No,
not?
I mean, I think there's a smell test involved, and, then it becomes a public issue when people hear about it, and you might get pressure.
It's gonna be political.
It's political, it's strictly
Well, but the
political.
political pressure, go ahead.
I think also, you could, they would have a strong case if they said people are dying and show people that are actually suffering from it. But even then, because the issue they're dealing with is pollution, which is kind of discovered over time, I think it would be difficult for them to bring in a strong case. They would have to do years and years of studies to even show that, people are greatly affected by it. So I think the government would trump either way.
Well, see, the activity had been going on, though, for quite some time. I think they had tried other means to take control over their own property. And the fact is that there obviously, these huge bombs are causing some damage. I guess that's the question is, no matter how much damage they show, at the end of the day, the court could still say, now listen, when I look at harm, the competing harms, and I look at public policy, you guys, this is a very, very difficult case for you to succeed on, and you're just gonna have to suck it up.
It's judicial discretion.
That discretion exists with this statute no matter what. Because the court did talk about this TVA case, right? TVA, where Congress said no. If it exists, the injunction must issue. But that's very different from the standard type of statutory and common law relief and equitable remedies under those statutes. At the end of the day, historically, and it appears after Weinberger, the court always has discretion to either grant or deny injunctive relief. As long as they assess it and look at the factors, and it's probably pretty hard. It is a general matter, obviously it's very difficult to beat the government anyway. But geez, if I look at the statute here, pollutant, discharge, point source, check, check, check. That's a pretty tough one to say, and you guys are going to lose nonetheless. Do you think they got justice? Is this a just result? They came into court, they had a relatively good case statutorily. Did they obtain justice? Can you say that the system functioned properly? Was this a just result? Or, well, what do you think? Well, no, that's what I mean, though. Did the people of Puerto Rico didn't get justice? It's not a fair result, or? Well, that's the question.
Can you see it as like the irreparable harm to the national security of the U.S. is greater than the irreparable harm to Puerto Rico? They never showed that they could run these naval maneuvers and not pollute and do the same things.
Well, that is their argument, right? There's going to be harm if we do this activity, but we must do this activity. And like now, except now it's obviously it'll be even harder, I think, to sort of make the challenge now where we have at least one, if not two wars we're engaged in presently. How do you argue that we shouldn't be properly prepared in this age? Even back then, there was a great concern of the Cold War and the like. So I mean, there were issues that were attendant to that. I want to come back to the justice thing because I really want to ask you that. But there's a couple other things I need to I'm looking at in the notes that I wanted to ask about that from a legal standpoint. It talked about laches, L-A-C-H-E-S, and it said laches should not totally bar the claims of Puerto Rico. What's laches?
Sitting on your rights for too long and then abandoning them?
And abandoning them?
Well, you've sat on your rights for so long that it's the equivalent of you having abandoned them.
But I filed suit here, so I didn't really abandon them. You're saying that I've lost the right to them just by sitting. What?
It's just saying that, well, the definition, I guess, is it's causing prejudice to the other side.
What's causing prejudice?
The delay in you asserting your rights.
So Well, so I'm not sure it's legal ambush as much as, I guess they're saying the plaintiffs waited too long to assert their claims, and it caused prejudice to them. Well, that doesn't seem quite fair, right? I mean, they're arguing they waited too long, but of course if they rushed off the first time a bomb fell, they'd say, oh, listen, come on, what's the big deal here? But so they try to work with them when we talk about trying to settle, trying to talk, trying to work with the other side, and then that can be used against you. Here they say they don't find it amounts to laches. What were we going to say?
Well, for the immediate irreparable injury section of the text, I mean, how immediate could it be if you waited so long?
What about that? That's the way that works? How do you argue it's an immediate irreparable injury, but you've been suffering this injury for about 5 years now? I mean, that does sort of undercut your argument.
You could say it's immediate now that the levels of pollution have risen to this.
Well, you're going to have to somehow distinguish it, because otherwise we are going to raise the issue of laches. There's another language in this footnote, I think it's footnote 4. It says, the very fact that there are in Navy zones modest numbers of various marine species, which are practically non-existent in the civilian sector of the AKs, or in the main island of Puerto Rico, is an elegant example of res ipsa loquitur. What's that mean?
It speaks for itself.
So what are they? That's the point about that these fishing grounds are some of the finest, most pristine in all of Puerto Rico. That there are species there which we wouldn't find anywhere else. It talks a little bit about the bond. So I don't know whether you're ever going to get, and you don't. The government exempts itself from that bond requirement as well. The court has that discretion. There's a footnote here. I'm not sure what number it is, but it's an important, it says the object of this statute is in some respects similar to that sought in nuisance suits, where courts have fully exercised their equitable discretion and ingenuity in ordering remedies. So when the court orders equitable relief or orders remedies, and it talks then about Spur Industries versus Del Webb, you guys still read that? You don't read Spur versus Del Webb anymore in torts? No? Boomer versus Atlantic Cement? No? Well, you're going to read Boomer at least here. The Spur and Boomer are cases where the court creatively tries to fashion relief to try and satisfy the needs, demands of both sides. And I think creativity is something we tend to drum out of you in law school, but if you're going to be a problem solver, you can put that hat back on and really try to figure out how to make, if it's possible, both sides feel like they've won. And I think if you start to think about when settling cases and trying to reach the other side, I think it really is important to you know, the expression that they use, which I'm not crazy about, is, you know, think outside the box. But the fact is there must be something that is comfortable for you that you can either do or pay me to resolve this case, and there must be a point where it makes sense for me to do that as well. And so if we creatively have to get there, and the court's going to do it in equitable cases as well. Both of these cases, Spur and Boomer, those are the coming to the nuisance cases, where the court then might say, well, listen, you've got to pay to remove that nuisance if you want to live there. Or we're not going to enjoin it, but we're going to order you to pay X number of dollars as a permanent measure of damages, and you can keep operating your cement company or your pig farm or whatever it is. The fact is, I think you guys have to be creative at times in thinking about how to resolve cases as you go throughout it. I want to come back to this justice point. Did the people of Puerto Rico, did they receive justice here? Or did they get screwed? What do you think? They got screwed. So that's the way it goes. And we don't care. You don't care? I mean, you don't care as the lawyer?
Well, that's why we're here. When we get through, we're gonna fix them.
Well, is that the right answer? But is that true, or did they get the just result, or did they get the legal result? Is what was done to them lawful and permissible and appropriate? Well, okay, appropriate, you decided to do it, but not just. But not just, so it can be legal, it can be lawful and legal, same thing. But it might not be just or right.
But you can look at that two ways. You can say even though that Puerto Rico got screwed, justice may have been denied to them, but you could also look at it from the other side of the, the scope and say, well, the Navy got its justice. So in any court proceeding
Did
or
the
any
Navy
kind of
get
litigation,
justice, or the Navy get what it wants, right?
well, I think I mean, in that sense, if you get what you want out of litigation, that can be construed as justice being served, whether you're the plaintiff or the defendant.
No, is that the same thing?
Some people
Because
would say
sometimes
so.
I want a lot more than I really deserve. Right? So all of us do, don't we? Stephanie?
Well, I mean, I think that, national security is obviously very important, and that if this training center was so important, then they should have gotten the permit, and I think the outcome would have been more just if they said, you know what, you can't do this right now, go get a permit, and then you can keep doing it. So that, like, yes, you're allowed to do this, but you need to follow the law, and right now this is the law, so just go get a permit, and then you can continue to do it. Instead of, well, apply for a permit, we won't give you any time limit, and you can keep doing this.
Yeah, what about that, right? I mean, the court could have said, and as Freddie sort of started us out here, the court could have said, go get a permit. And if you don't have a permit in a year, we are probably going to shut you down. Or maybe we have to say, well, we'll say we will shut you down. Right? They could have staged compliance with the order. But they didn't do that. And that would have been probably fair. Okay, we understand national security. Take care of your issues. Either stop polluting or get the permit. You've got 1 year. And we all agreed. They had the discretion to do that, right? So they didn't even do that, right? They came with what seemed on the merits to be a pretty solid case, and they got nothing. So that's not just, is it? You said the Navy got really everything they wanted, so they got what they see as justice. No, they got everything they wanted. That's not necessarily justice. Let me get Alina on quote.
I just think now that I think about it more, it was a complete slap in the face to the people of Puerto Rico, because the decision alone was kind of like saying, that's great that you came here and you argued your part, but we're not even going to give them any sort of restrictions. They're just going to continue with doing what they want to do, the Army. And the no time limit thing, I think, is
Well, they got nothing.
Yeah.
They didn't even throw him a little bone, did he? So is there a difference between justice and what's right? Between what's legal and what's the appropriate thing to do? Or are they the same? Because there's nothing wrong with this decision, right? It's within the court's equitable discretion. It is the law, and the law was applied, so it's a legal, lawful decision. But it's not just, or you don't care when you represent the Navy. Go ahead.
But don't you think, I don't know, something tells me that I feel like it would have been different if it was like, say, the people of Massachusetts suing because they were, polluting Boston Harbor.
Oh, so you're going to raise that issue, huh? What about that?
Well,
Oh, really, right? What about that? What about that? It's people of Puerto Rico. Some of those folks don't even speak English, who the hell cares? Right?
Because then the pollution extends all across the coast of the United States.
But yeah, let's not do it off Texas, or Florida, or certainly not off Massachusetts. Do it off there. Who the hell cares about them, right? Is that so some of that's here? Because now you're not just telling me it's not just. You're telling me that there's an animus there that really is troubling. So we come to your courts, we ask for your help, we do the right thing, and you say,
Go away.
go away. So how does that then, this whole notion about justice and what's right and what's lawful, how does that resonate with the way you practice law? Go ahead.
Oh, I was going to argue.
No, go ahead. You wanted something? Go ahead.
I was just going to say, I guess I'm the one on the class that thinks it was just because, I'm pretty sure that Puerto Rico is, aren't they considered a territory of the U.S.?
Yeah.
So they are part of our nation, basically, and So they get the same protection that the rest of us are getting, so they are getting a just decision, because if there's an issue to national security, they're involved in that. They would just be at issue also. So.
Yeah, but we're getting the ass end of national security
Yeah,
here, aren't we?
they both-
I mean, no, really, aren't we? You know, not to be crude about it, but, okay, you guys get all the protection, we're getting everything that's left as a result of you guys getting all the protection. Oh yeah, and we'll protect you too, that's.
But if they didn't want to have the training there, they should have never allowed them to have training there.
Well, that may be so, I'm not sure how much allowed, you know, when the Navy comes, no, really, right, when the Navy comes in and says, we're here to help you, just get out of our way,
Right.
whether there's that whole process of you guys want us here or not.
I'm also pretty sure that, you know, when the Navy comes knocking on anyone's door saying, hey, we're gonna set up a training facility here, for that state or that territory, that equals jobs. So, I mean, are you gonna turn that away and say, well, see you later, Navy?
That's what I mean. I just think that I do think it was just. I think they have the training situation there. Yeah, they might have broken law, but there were other ways they could have gotten around it, and instead they are going to try to apply for a permit now, whether that was because the court told them to or not. But it said in the case that the president could have granted them an exception from even requiring a permit. So they could have just said, you know, too bad, we're not even going to go.
See, I would have felt better about that. I would have felt better if the president just mans up himself and says, you know what, I don't care. I don't care, no really, right? I don't care about Puerto Rico, I don't care what they want. Here's your exemption, you're good to go. Now at least the law has been followed. The law says you can't have pollutants, you can't do it this way, but there's a permitting process or there's an exemption, and the president of the United States can say, Ronald Reagan at the time could have said, you know what, this is more important than anything else, I'm going to sign the exemption. At least then, the closer to the rule of law. Are you comfortable that the rule of law was followed? Or, yes, it was followed, literally, and so the fact that the people of Puerto Rico may or may not have gotten justice doesn't really matter at all. It's not, we're lawyers, we don't look for justice. We look for representing our clients and winning. And hopefully, somewhere along the way, justice might occasionally run the same path as us, but I don't really care if it does or not.
As long as you get paid.
No, is that true? That's true. That's you. That's your role. You're not an advocate for justice. I should forget all of those personal statements of yours I read about when you wanted to get into law school, be a lawyer, and change the world, and now you don't care about justice at all, or not as an advocate. Is that right?
You can seek justice, but you've always got to do it through law, and law doesn't necessarily put you where you want to be.
So you can seek justice, and occasionally you might get it, but it's not the goal of the litigation. Not as an advocate. You don't care. You know, the dissent, I really like this dissent a lot. And there's some things in the dissent I wanted to ask you about. And because he really ties into it a little bit. He on page 333 of the decision, he says the courts, and he's referring to the majority, the court's sophistry is premised on a gross misunderstanding of the statutory scheme. What's that? Sophistry. Sounds.
It's very Socratic. Basically, the sophists were people that propounded to know everything. So
Is that what it is?
I think in that context, he's.
You know, sophistry
sort of,
isn't discretion, and I'm not so sure it's wisdom.
No, it's feigned wisdom.
Feigned wisdom?
It's a good argument.
Huh?
It's a good argument that isn't actually reasonably sound. It just sounds good.
It sounds good on the face of it, but it's deceitful,
Yes.
dishonest, duplicitous. So he says in the dissent that the majorities are liars,
Yeah.
that they're using false logic, sophistry. Is that true? That's what he says, right? That's what it says in page 333. He's saying, oh, this is a bunch of hooey what you guys are selling here. You don't expect anyone to believe this, do you?
Isn't that what all dissents say?
Huh?
Isn't that what all dissents say?
They accuse them of sophistry? That seems like a pretty strong attack, Geneva. That doesn't seem like,
I feel like
you know.
in common law we read a lot of.
Well, that's true. The Supreme Court decisions, especially when you look at some of the attacks more recently between the majority and the dissent, are oftentimes quite cutting. I agree with you on that. Let me ask you about the last paragraph, the last footnote here. And it comes from A Man for All Seasons. And so that's why I like this, because I think it's an interesting dissent. And what he says in the footnote here, and the lines are attributed to Sir Thomas More from A Man for All Seasons. He says, "The law over the law, I know what's legal, not what's right. And I'll stick to what's legal. I'm not God." And you can read the rest of it. And it goes on, it finishes with, "Yes, I'd give the devil the benefit of the law for my own sake." So is that what you as a lawyer, you know, when you leave, or now, you know the law, you don't know what's right? Or you don't care what's right, you care about the law? Go ahead.
I don't think that's true. I think there's a combination. I mean, you have to be realistic in life, be naive to think that, I mean, even reading cases, there's a lot of times you look at it and go, I think this would have been, the outcome would have been different if it wasn't, 1962, it was 1990. So you have to be realistic going in and know that you want to fight for justice. However, not be naive and think that politics and social pressures don't play a role too.
Well, okay.
But ultimately, I mean, the law has to be followed. You can't allow emotions, but you have to, but you have to realize that there's a lot more involved.
I agree.
Underlying the service.
I agree with that. But so when you're representing a client, do you care about justice, or do you care about zealous advocacy on behalf of that client? Do you care about what's right?
Well, I think in order to do your job, you have to care for your advocacy for the client.
So what's right doesn't matter. So you can.
Well, I mean, with a criminal, I mean.
Yeah. I want to know though. That's what I'm trying to plumb.
You know, it's pretty clear that they're guilty. They're still entitled to representation, but.
So you don't care what's right.
But I'm thinking if that was my kid, I would, you know.
No, but you're the advocate now. That's what I'm asking. Your role. Listen, you're not. Well, I'll say it. It sounds horrible. So you're not a person anymore. You're a lawyer. Yeah, we're all nodding our heads saying, yeah. That's the deal I signed up for. Or so as an advocate, what were we going to say?
I was going to say that you paint what's right as black and white, and what's right is gray, because we all look at what is right from different viewpoints and from different backgrounds, and especially, and what this case reminds me of too is, who wants the garbage dump in their backyard?
So wait a minute, okay, because that sounded really nice, and I'm going to let you finish it. But so there really is no right. At the end of the day, there's no right. It's each what we decide it is.
But there's right that there is a right, but what you say is right, I may not think is right.
So that's all I'm asking. I just want to make sure there's no universal rights. It's what she decides is right. It's what she does. What I do.
But we do have the law, and we have what we
No,
hope
but is that true?
just.
You are willing to accept that there are no universal truths. There's no universal rights. It's right and wrong. What our mother told us was incorrect. There's no right or wrong. It's what you want it to be.
But I think they're gray.
No, is it all? It's all gray. There's never a
But
right.
that's why we have the law. That's why we.
So that's right. So forget about. You don't need to know what's right because it doesn't exist. No, is that? Do you all?
Yeah, that's psycho.
What do you say, Jack?
I completely.
You'll go with that. There are no rights anymore.
No.
That's what he said. That's what
It's just on a pendulum. I mean, for everyone.
wait a minute. On a pendulum for everyone, so that depends on who I represent as to what's right or wrong. Because I thought legal is one thing and right is something else.
I agree with you.
But I don't.
But right, there might be multiple different scenarios that are right.
There's shades of gray, as Karen says.
Right.
But there are some right and wrongs, aren't there?
Well, there have to be some, okay.
Like what?
Abortion. When does life start? Some people believe it starts at.
Okay, listen, we got plenty within the case. We don't have to talk about abortion. Okay, nice try. because I really do want to focus on your representation, and that this is the underlying question. So your own views of right or wrong have zero to do with your legal representation as a lawyer. I see a lot of heads nodding. I'm going to take a show of hands on that. Yes, raise your hand. So those of you that are saying no, would you like to join the discussion? Because there's about at least a third or half of you saying, no, it has to inform some of my representation. No?
If it goes completely against, yeah, and if it
What?
goes completely against my moral fiber, I'm gonna turn you away. I'm not gonna do that.
Okay, so there will be clients
I
you
mean,
turn away because of
absolutely,
what you see as
from
right
a
or wrong.
private
Now, you're
practice,
nodding your head over there a
absolutely.
minute ago. You said it's.
I agree with that, but if I'm able to play, if I'm able to place my opinions aside, which hopefully I can, because my opinions are not all, although I do think that, but they're not always correct or right. I can't make other people believe what I believe. I can't do that. So how can I do that for my clients? But I still have to defend them with my utmost abilities.
So there's Mike the lawyer and Mike the person. And they better not be in the same room.
But isn't that true?
Isn't I'm asking you because you're the people that are going to have to figure out how you're going to align this.
I think as far as this case, the problem was that and we talked about this, that they really didn't show the damages enough. And that's what really, that case wasn't proven.
So it is, well, so they failed under the law because they didn't show damage. So
yes,
they got justice. You can say that. You can say that. Look in the mirror.
Did they meet all of the elements of the statute? Though? Like with the pollution and all that stuff? They met all of that, right? They just didn't show any harm
I
from
think
it?
if you tick down through the statutory requirements here, it's a summary judgment case. Right? Yeah, technically, that's right. Let's look at that, what Freddie says. The court even says it's a technical violation, right? They say, God, there's a statutory violation here, but then they go on to say no harm, no foul. So you know what's legal, not what's right. That's what the line says. Fiona, what are you saying? No?
I don't think that we can exist as two separate individuals. I think a lot of who we are and our morals determine the type of lawyers that we're going to be. So I would hate to think that each of us are going to be two different people when the day starts. And when the night comes, I don't know.
Just check your values and your sense of right or wrong.
I think
at
who
the
you
door.
are and what you believe do influence the job that you would perform as an attorney. That's what I think.
Well, then how do you, as was used for example, how do you then represent the child molester?
I do exactly what the law states based on what he says to me.
Okay, well, what do you mean what he says? He says, I did it, but I don't want to go to jail, get me off.
Well, he might have some kind of mental problem, I guess the law might say. Argue that to the best of my knowledge.
So you're going to argue for the release of the child molester, and you're going to win. Now he's going to go out and molest someone else's child.
No. Then I guess I would have to try to convince him that he has a mental problem and get him in some institution to get some kind of help or medication.
Yeah, listen, you're not my doctor. Yeah, I'll think about that. Thanks a lot for all your help. Right? You got it, right? Do I get to go now? So go ahead.
Then you have a crazy molester running around, like after you're done defending them. And
But you're a great lawyer.
Right, but
And that's
I would
those.
turn that client away. I would turn that client away. I think there is a difference between what's legal and what's right.
But he's
And
entitled to a defense.
Exactly.
that's true, but you have a choice
not for
to.
me.
But you don't know that he's
Okay, he's entitled to your defense. She's saying not necessarily entitled to mine.
Right.
Okay, and I agree with that sentiment that, but you know, you don't always know you got the white hat or the black hat until we're a little further down the road. Now what? Because then, go ahead, what?
The cases aren't always that extreme where it's the child molester. It might be
Agree.
a civil case where you are representing somebody and you, in the course of representing them, know that you can win this by using the law to the benefit of your client, even though it might not be right. And that happens all the time, but that's your obligation to your client.
So that's the deal.
Right. Even though you know the
Freddie's
outcome.
example is much closer to reality, right? It's easy. Oh, okay, I won't represent child molesters. I won't represent the drug dealers. And if that's your position, that's your position. Others would say, well, they're entitled to a defense, especially if they can pay cash, right, Scott?
That's different. That's another
But you're representing the big corporation, and you know the person that, you know, the victim here, the plaintiff, you know, probably, you know, suffered, and probably it's their fault, but you can win.
Right. You can win, you can wear them down,
You're
walk away.
obligated to do that, you know, I mean.
Obligated? Because that's what it is, that's the deal. I'm obligated then to do it, and so the fact that you've made someone homeless as a result of your superior advocacy skills, you just give yourself a little pat on the back. There's no, oh, you go to church on Sunday or whatever, wherever you go on Saturday or Sunday, and then say, okay, this is good. I'll say a little prayer. I'll say a little prayer that his cardboard box will hold up this winter, and he'll be okay. And that's going to make you feel better? Or does this, I seriously
Well,
don't.
we take the case ethically, you have to do what's in the best interest of your client.
No matter what.
Unless you're breaking the law.
No, you're not breaking the law. I think Fred's given us a good example. There will be times where you will have the unjust client who will win because of your skills and the lack of skills perhaps on the other side, and it won't be the right result.
But you're doing the
But you
right
won.
thing in the profession, because the
But that's the right. So the right thing in the profession is to do wrong.
No, it's to do with the best, to do right by your client.
But it's not necessarily.
But it's not the right thing. It's not the right thing.
But
There's
for us
legal
as
rights.
lawyers, it's the right thing.
That's why so many people
So
don't
there's,
like lawyers.
there's a legal thing. So we're back to where we started. There's the legal thing and there's the right thing, and they really aren't the same.
Sometimes they coincide, though. There's legal rights and moral rights and ethical rights, and sometimes they coincide with each other, and other times you have to differentiate it for the basis of your client.
So go ahead, Rick.
But even in the case of, you know, the extreme cases involving the child molester, I, as the advocate, don't want to know whether he did it. Because if I know he did it, then I'd be perjuring myself in front of the court.
No, you wouldn't necessarily. You wouldn't necessarily. You have the right. That's the whole issues with that. You still can be the advocate. The limitation is whether how and the manner in which he's going to testify on the stand. But quite often you're going to represent people who you know. And you're going to represent that they didn't do it or that they're not guilty, even though you know otherwise.
But we also,
one way to get
also
comfort
have
in that is guilt or innocent really is a legal decision, right? Whether they did it or not, that may be factual, but guilt or innocence means that the government has proven guilt beyond all reasonable doubt. If that allows you to sleep any better.
Interesting thing you just said.
Ray, I cut you. You're right.
but I was
Not
gonna
guilty does not.
No, but I
mean
was going to
innocent.
say, you know, at the same time, everyone in this country is entitled to a defense, whether it be, you know, the case of the child molester or the person that was, you know, caught with, you know, a firearm. So when someone comes into my office and says, Ray, you know, I have this problem, and I turn them away because, well, I don't want to defend, you know, the child molester. I mean, I think that also brings into question a lot of, you know, ethical issues as well. Am I allowed to turn away people because I don't agree with a particular political view, or if I don't agree with abortion, do I want to turn them away? I probably can't, because everyone is entitled to legal representation and access to the courts.
They're entitled to your legal representation?
No, but they're entitled to access to the courts. I mean, if every lawyer in the state of Massachusetts said, well, I'm not going to represent, you know, child molesters, well then, effectively, what we're doing is we're denying those people access to the courts.
Well, they get court appointed.
My guess is there will be some that wouldn't complain. Some lawyers, as Fiona points out, would still take them, and they would have a lot more work to do. And there will be others that would not cry at all for the lack of access to the courts of child molesters. So my question originally here was justice. And now we're saying right, and I guess is right justice, or, listen, I'm a lawyer. I don't seek justice, I seek to win on behalf of my client. Justice, not on my radar screen.
Like, it could be, justice can mean two different things, though. It could mean moral right, or it could mean, like, a legal right.
So justice is really only defined under the law.
To me, justice is defined as truth, and obviously, if you're defending a client, you find out you're going to violate your obligation to your client if you're not going to, you know, be the best you can for them.
So you don't care about justice?
No, I do, but at the same time, you have to care about your ethical obligations to your client.
Well, which is paramount?
That's the
That's the question.
proverbial beach to cross. Yeah.
No, you need to cross it now is what I'm asking. Which trumps? The desire to have justice or the desire to win on behalf of your client? What were you going to say? You said you had to wait.
Well, I think, you know, it's.
What's your name again?
My name's John.
John.
It's an adversarial system, and I think, you know, I think that each party, I kind of lost my train of thought.
It's an adversarial system. Each party, my guess is somewhere along the lines we're going, each party is supposed to do represent their client zealously within the bounds of the law.
Yep.
And if somehow through our mutual efforts we land at justice, great. Otherwise, who cares? Obviously, I'm that in the last
I would
one.
also-
You were going to say that.
I would also say that I think you have to have a little bit of belief that that what's right and what's legal, that we're trying to get what around in the territory under a given set of circumstances, what is right, is we're trying to go for that through the law.
Well, what about good
because
one?
if the law was, you know, if the law is wrong, then people have less incentive to follow it.
Okay, so we've got to believe that, and I'm going to change it slightly to something. We've got to believe that while justice isn't necessarily our job, that's the job of the jury or the judge. And so we do our best with what our role is in the adversarial system, and we fight like crazy to see our client win. And hopefully, the really bad guys won't, because that's the judge or jury's job. But it's not. But again, it's not your job. Is that perfect? 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 It is. No. So is that right? It's not your job, and that's okay.
Well, you just said a minute ago, he didn't do it, he's not guilty. And those two statements don't belong in the same breath. You know, you can't.
I don't.
There's a difference between did he do it or did he?
Oh, right.
Is he guilty?
They don't mean the same thing, right?
Right.
Right. The fact that he did it doesn't necessarily mean guilty.
Right.
Yes. Go, Stephanie.
Well, like, when we were talking in the criminal context, I was gonna say that, you know, you do the best that you can and you act, or you represent your client as zealously as you can to uphold their rights and to win. And if it's something that you don't believe is right, or you think that they really did it or whatever, you hope that at the end of the day the prosecution did their job, and that outside at the end of it, like, the justice system will prevail. But you still, like, your primary obligation is to that client to protect their rights and to provide the best defense that you can in court.
So your job is to hope for justice, but if we don't get it, we don't get it.
I just want to say, like, when I came here to law school,
Yeah.
I'm a domestic violence advocate, I'm a survivor, and I will always be on the side of, you know, domestic violence rights. However, and I came here wanting to be a prosecutor, so I've been here for 3 years, and now I, like, have been taught to look at it both sides, and I can now see myself, I could see myself doing a representation of a batterer. I mean, it doesn't mean I'm leaving the rights, but just because of what I've learned about the adversary process.
Okay, help me with this though. I imagine much of the information that we have as batterers will repeat, right?
Yes. Well,
without treatment, without.
Well, I work at a police department, so I see arrest reports every day, and I'll tell you, like, some guy who just grabbed his girl while she was walking away is gonna get locked up. And it could be just like they're having an argument, no, don't go away, and somebody saw it and said, oh, that guy's grabbing that girl.
No, he punched her square on the face, broke her nose, blood
Well,
all
yeah.
everywhere. No, and now he wants you to represent him. You good with that? You're a lawyer now.
Yeah, if that's my job, if that's the position that.
He says, don't worry, she won't testify, she knows what's good for her. I'm serious, that's because you said you now can see both sides.
Yeah.
So then you get them off. You don't feel some tension when you wake up the next morning and look at yourself in the mirror, or is that okay? I mean, And all I'm asking you to figure out, you know, where your own sort of center is here, because if that happens again, my guess is you're gonna feel bad about it, right?
Yeah, definitely.
Sometimes
I feel bad
sometimes the
about it in
violence
first-
escalates,
I
right?
feel bad about it in the first place, but I've learned in the last 3 years that you know, about the law, and I mean, I don't think of it as a chess match, but like, it's an adversarial process. Like, I'm more into the game of the prosecution versus the defense, like the legal arguments. You know, I'm not really into whether you did or not. I'm into the game.
So you come as a domestic violence advocate, highly competitive and interested in the game. Wow, my colleagues have really done a great job.
Put that in the MSL commercial.
Go ahead.
I just want to say, I might, you know, cold, but me, I would separate the two person. The Mai is a mother of two, and the Mai is an attorney. Because if I am the right and legal, because what is right, it's not legal all the time or vice versa. So if I'm going to use the court system to achieve my goal, which is winning my case, I care about the legal means that I'm going to use to win the case.
That's all you care about.
It's a game.
Well, but is that so? That's it. So we're listen. Then we're mercenaries, right? Whoever wants to pay us, that's who we fight for. And you give us enough money, and we'll fight for you. Period. We're whores.
I like mercenaries better than
You like mercenaries better than him? No, but we are, right? That's what we're saying is we don't care which side we fight for. We're going to fight, and if we pay good money, we'll fight really hard to win. And the carnage that's left in our wake, that's not our problem. No, because right, you must realize that when you win, someone else loses, and you do leave a real mess in your wake here.
Yeah, but we didn't write out the process. We just joined the process.
So we just joined it. Whatever happens, happens. And the fact is that you just don't care. Melanie, you just don't care.
I have a really hard time with that.
But
At the end of the day, I have to face my kids. I have to face myself. And I don't want to wake up in the morning and say, oh my God, what the hell did I do yesterday? And when I die, I don't want my kids saying, my mom, she was a great advocate. She got all these child molesters off. She got a murderer released. She did this, she did that. I want them to say, my mom did something good.
What about that? I mean, there must be part of you that came from law school that even now says, okay, listen, if I can make a decent amount of money, pay off my student loans, and do good, and do the right thing, I can do that, Professor Coyne. You must at least feel that way, right? I mean, ideally, you must want to represent the white hat. No? Right? You know?
Yeah,
That's
no,
the
I-
Go ahead. What?
Yeah, that's why I'm here.
Right.
In the beginning, maybe I'll represent bad people. But
Well, once I get a little bit of a cushion,
Yeah.
my bad days are over.
It depends on what your makeup is and what you want to do on an individual basis. You know, you want to do wills and trusts, you do wills and trusts. You're not going to be asked to defend a criminal. You couldn't do it if you wanted to.
No, but you know what I want you to say? I want you to put in that will that I leave my son Fred 0 because he's been nothing but a rotten, heartless bastard to me all his life. Will you write that in that will?
Yeah, my dad did the same thing, so screw him. I'm joking.
Are you going to write that clause? Sure. Sure like that? Sure like that? Leave this baggage on Fred for the rest of his life? But, you know, my mom, when she went, she said, and she made sure everyone in the whole world knew it. You're not going to have a conversation with, okay, listen, I understand you're presently mad with Fred, and you don't want to leave him any money, and we can take care of that. But I think you're a little over the top with rotten, heartless bastard. And no, that's not a conversation we should have.
There's nothing wrong with that conversation, but at the end of the day, if he insists that's what he wants, he's entitled to it.
Oh, but then you know
It's not my
what? Go get
choice.
someone else to write your damn will.
No.
No. You're going to lead.
It's not your responsibility.
Go ahead.
Well, I think, you know,
up upon it is that that's why you take your personal choices, and maybe you're not gonna be, you know, a civil rights attorney, or you are, or a, legal defense, or you are, because of what you personally believe is just, it's like,
Okay,
I
but this
work
was
in-
a will and trust, okay?
Yeah, I agree, but at the end of the, but you cannot internalize everything and fix and cure every ill of the
But
world, like I work.
you're not internalizing anything as I hear it, right? I haven't heard anything that touches you enough to say, that's it, that's where I draw the
No,
line.
but
You work in what?
But I
That's what.
think, no, I work in healthcare, and I can't, a person comes in, and they're bleeding out and they're gonna die. I'm not gonna treat the gangbanger any differently than the, than the person who's just instantly in the accident.
I would, okay, I would. How many of us would?
No, let me finish my statement. Let me finish my statement though. At the end of the day, you're gonna treat them both, but if you can only go to the police officer or the gangbanger, you're gonna go to the police officer and stabilize them first.
Even
That's
though he's
the
in a less
human
dangerous
side.
condition.
Well, no, if they're both in the same condition, but if he's in a
Now,
less dangerous
gangbanger a
condition,
little worse off, police officer just a little better.
then you're gonna go to the person because you went into helping people for, you have an obligation, and part of it is a moral obligation that you decided that you were gonna help people. So in whatever you do in life, you have to decide personally, and sometimes you have to step back. There are patients that occasionally I'm like, I'm not taking care of this person, someone else has to do it. Because you have to know that you're still a person, you have to live with yourself at the end of the day, but at the same time, you can't internalize every ill in the world. You can't be responsible for thinking, what every ill somebody's gonna do. So it is a personal balancing act, I agree with, you have to live with yourself at the end of the day, but I think Scott's right, that's why you go into certain areas of law and not others.
But didn't you guys, in part at least, come to law school to do the right thing?
No. I
Who
did.
said no
Yes,
over
I
there?
did.
Geneva, no, not at all.
I'm doing the legal right thing, but my
Wait a minute. I've been told that the legal right thing is an oxymoron.
No, I think that according to law, and you do things the way that you're supposed to, and I completely agree with it. Is it Karen?
Yeah.
Yeah, I can 100% agree with her, because I think that everyone's right is different. So, for example, if someone murdered somebody and I'm attempting to get them off for whatever reason because they weren't read their Miranda rights, everyone else is going to think that is wrong. They belong in jail, they murdered someone, or a death penalty, whatever. And I can have my own belief that the right thing is he should have been read his Miranda rights. So I'm going to see that differently because I'm a lawyer.
Well, so that's what it is. Your moral imperatives really don't exist at all. They're the legal imperatives. No,
When
right?
I'm doing my job. Because if I were to talk among friends, not as the lawyer, I would say, like, oh yeah, he probably belongs in jail and he should have been there. But that's also, again, why I wouldn't pick to be a criminal defense attorney.
But see, then aren't you setting yourself up then for more tension with respect to being able to look at yourself in the mirror and say, no, Geneva the lawyer is different than Geneva the person. I actually care about kittens and little kids in my practice. Beyond that,
I think
no.
that makes us stronger people.
Does it?
Yeah, because we have the ability to.
Sounds like getting ready for crash.
I just feel like.
Wait a minute, I'm going to cut her off.
Oh no, I think that sometimes you have to do that. Like when my mom had to go to work, she's an air traffic controller, and she had to be very serious. Not the mother, not like caring about her children, even though that's all she cared about on the inside, because she had to do her job and she had to act like a man in that field. And I think a lot of people have to do that when they go to work.
But I don't think you can look at the law that robotic, because there's some laws, like even going back that maybe not exist now, some laws that were affecting people of color, affecting different social classes differently. I think as a lawyer, I'd like to challenge those laws that put,
And you can't, because you think they're right or wrong.
No, see, but I'm saying, but if you were to follow that, you'd say, oh, this is the law that's right, then automatically, the way that you're reading it, if you say it's law, if it's in law, then it's automatically right, but
Right,
that's not.
because you're going to have an opposing person who's going to say, no, this is the right law. And that person thinks that's the right one, and they're going to go with that. And I don't think you can oppose a law. I think that a lot of people bring that, or they bring cases for the sole purpose of doing that, and that's what they feel is right.
But Geneva, he's asking a question, and I'm going to reframe it a little bit. He's asking, you would enforce a law that you personally believe is absolutely unjust, but it's the law.
If that is my job to do it, then I would have to do it. Because I agree with a lot of people saying that, you know, oh, I won't take that case. Well, sometimes you don't have that opportunity. Sometimes you're in a firm or you work for someone that the government, they say this is what you're taking or you're going to be fired. And then in that case, like with your children, you need to worry about, am I going to have a job to support my children, or am I going to have to put my emotions aside and do this job? So even though I might not think the law is correct, then I'll have to go about it in a different way. But at that moment in time, if that's my job and I have to defend it because that is what the current law is, then hopefully other people will lobby the politics and everything and change it. Or I can bring another case some other day when it's not my job to defend the law.
You read a lot more of that paragraph that I left off. You ought to look at it carefully, because the point he is trying to make is that, it's in part Karen's point, is that, you know, if we all sort of are left to our own sense of what's right and wrong and sort of disregard the law, then it becomes really a mishmash of who gets what rights and how does it all work, and my right may be different than yours. But I do think that there are probably some universal ones that we could agree on. I just think you guys have to figure out where your own sense of what you will and won't do, and how your own value system, how that affects how you practice law, because you're going to be called on to make those questions, to respond to those questions. I've got to do 2 more cases, Scott, so I just want you to think about Clinton versus Navy. And I think what's good about this case, and it's not right or wrong, but they talk a little bit about a class action. But I think if you look at this case, what's kind of interesting about it is the manner in which and the timing on which they seek the TRO. The fact is, what they do is they wait till there's so little time left in the season that the likelihood is that the temporary restraining order is going to be dispositive of the entire case. And so when they do seek and obtain it so that she can play Little League, the fact is that that district court judge is really resolving the entire controversy for all intents and purposes. And so I do think that you need to think about the seeking injunctive relief early as a means of gaining a significant tactical advantage and perhaps mooting the entire rest of the issue. And that's really what is done there. And it's an interesting case to see how that's done. Remember how a TRO is sought, or a preliminary injunction is sought. One side goes in with all their evidence and information. You may get notice, but that notice might be days or no more than a couple weeks. And the other side has been planning to go in for some time now, has both their evidence and witnesses ready. You're at a pretty significant disadvantage right from the outset if we're going to go in and ask for a hearing on the TRO or preliminary injunction. So you have to marshal your evidence and your arguments very, very quickly. I thought that was a really good illustration of how to use it from a timing standpoint in order to succeed and get the little girl what she wanted, which was to play football that season. Norwalk Board of Education, the case Scott wanted us to do early. If you look at it, here they are also seeking a TRO, and it's referred to as maintaining the status quo. That's language we see a lot with respect to temporary restraining orders and preliminary injunctions. Maintaining the status quo really means to leave the parties where they were before the last uncontested spot. So what you're trying to do is, during the pendency of the litigation, not have any more damage that takes place. Again, in Norwalk Board of Education, you see them argue about laches, which is a very common equitable defense, and it's not statute of limitations. You're simply saying that there's been a delay in asserting their rights that has caused prejudice to the other side. There's a couple of other issues to look at here. We're really run out of time, but they have a motion to intervene. You should look at that motion. We're going to look at it again before we're done this semester, and also class action. Class action, I think all of these concepts, all of the stuff that hopefully you touched on in Civ Pro, as we go through during the course of the semester, don't just leave those concepts aside. The idea is to start to look at it now and see how it operates in the case, and see how different causes of action are used and employed to try and obtain remedies. The last thing I want to touch on is the articles on settlement and trying to use mediation. I think hopefully you'll look at those articles. I know one of them we're going to post online, settling the score, which I'm told was not in all the on all the CDs. The fact is that more and more now lawyers are expected to look outside the court process for resolution. And the fact is it's both cost effective from the client's standpoint, and it may also be advantageous. But even when we go to a mediation and the like, we still prepare all our information and we still have to be advocates. The fact is that you're just advocating in a different forum, so you still use your advocacy skills, you'll still be presenting case and your information, and now you'll be needing to add to those skills your ability to negotiate and think creatively to try and solve the case. So we'll see you guys next Tuesday. Thank you.